بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين على نبينا محمد وعلى آله وصحبه أجمعين. اللهم لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا إنك أنت الجواد الكريم. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to our second episode in a series on Islamic legal maxims. Today's episode is actually technically not considered a legal maxim per se, but it's so important to any process of thought that it should be given some attention. This maxim is al-hukmu ala shay far'un an tasawwurihi. Judgment on anything is to be based upon understanding it. So in order to understand the maxim, we should look at the words that comprise it, first of all. Linguistically, in Arabic, al-hukm means judgment. And a more technical definition of it, which is still not a fiqh definition per se, is nisbatu amrin ila amrin nafyan aw ithbata. This means to relate one thing to another, either to negate it or to affirm it. So actually any kind of a declarative sentence is a hukum. If you say, I feel hot, you're attributing the feeling of heat to yourself. If you say the sun is 93 million miles from the earth, you're attributing this distance between the sun and the earth. So a hukum linguistically can be any declarative sentence. So if you say the sun is 93 million miles from the earth, you're affirming a relationship between the sun and the earth, a distance. And if you say that in fact the sun is not 93 million miles from the earth, then you're negating that same proposition. So one or the other of those would be true and one of them would be false. So any judgment about anything should be based upon knowledge. A shay in Arabic means thing linguistically. And a more technical definition is anything existent outside the mind. And the reason for going into this is that things exist outside our mind, but we develop a mental picture of them inside our mind. We deal with the world based upon mental models. And that's what this maxim is all about. So, al-hukmu ala shay, judgment upon anything, far'un. Far', if you recall when we were talking about, in the first episode, we were talking about asl and usul. We said that asl is like the trunk of a tree, and the things that branch off of it are called furu'. So far' is a branch in terms of things that you can touch, like the branch of a tree, but in abstract sense, anything which is derived from anything else is far'. Anything which is dependent on anything else is also far'. So the final term in the maxim is tasawwur. Tasawwur comes from the word surah, which is picture. So sawwara means to form an image or to create a statue or a picture of something. Tasawwara means to do the same thing, but inside the mind. So al-hukm ala shay far'un an tasawwurihi means that in order to pass judgment on anything, you have to first develop an accurate mental model of what it is that you're passing judgment on. So you see that Al-Ghazali, rahimahullah, in the muqaddimah, the introduction or the preface to his final work on usul al-fiqh, which is al-mustasfa, he talks about this principle. This is a fundamental, it is the fundamental starting principle for any mental activity, intellectual mental activity. And other scholars followed him in this same assertion. They agreed with him on it. So for instance, As-Subki and his son mentioned it in a book that they did on usul al-fiqh. So Al-Ghazali, in his book Al-Munqidh min al-Dalal, he discusses the attempts by various Muslim scholars before him to refute the writings of Muslims who were adherents of Aristotelian philosophy. And he observed that they were taking little snippets, statements from here and there, from the writings of these people, and they showed no sign of understanding the overall system that they were criticizing. And sometimes they were even attributing positions to the people that they were attacking that they hadn't actually stated, maybe because they misunderstood. All of it indicated that they hadn't really studied the thing that they were criticizing. And Al-Ghazali mentioned that he sat down and he studied philosophy for 2 years, took apart all of their statements, understood them thoroughly, and then he wrote this famous refutation of their ideas called Tahafatul Falasifa. Now, going back to Qawaid Fiqhiyya and the relationship of this maxim to fiqh issues, the meaning of the word hukum, it has a linguistic meaning and it has a more specific meaning when you come to fiqh, because the attribution of one thing to another in a fiqh context is the assignment of a sharia value to people's acts. That's what a hukum is in fiqh. So most Muslims are aware that it's not just good or bad. There's a 5-part classification scheme, which is wajib, that which is obligatory. If you do it, you have a promise of reward. If you don't do it, you have a threat of punishment. And the opposite of that is haram. If you do it, you have a threat of punishment. And if you don't do it consciously, that it's because it's haram, then you get a reward. And then you have the mandub, which is that which, if you do it, you have a promise of reward. And if you don't do it, there's no threat of punishment. And the opposite of that is makruh. If you don't do it because it's makruh, then you are promised a reward for that, for your abstention. And if you do it, then there's no penalty. And mubah is neutral. It's permissible, and there's no reward or punishment per se attached to the act. So this is the hukum shar'i. And in order to begin to discuss any topic in fiqh, you have to start with definition. So for instance, in any fiqh book, like as-sariqa, theft, in discussing, before even getting to the hukum for it, the discussion will start with, well, what is sariqa? What is theft? And they'll define it: to take something secretly from a protected place, something belonging to another person, taken secretly from or furtively from a protected place. So based on that definition, there are certain things that cannot be classified as theft. So if somebody comes up to you on the street and puts a gun in your face and says, "Give me your money," that's not sariqa Islamically. That's something else. It's not sariqa. And if you leave something in the middle of the street and you go away and you do something and you come back and it's gone, well, somebody took it, but you didn't leave it in a protected place. So definitions are really important in fiqh issues. And so if there's another word, like in Arabic there's a word for someone who digs up a grave and takes the funeral shroud off the body. You know, in previous times, people were so poor that they would steal cloth from a grave. So there's a specific word for that, nabash in Arabic. So because there's a specific word for it, then scholars discuss the issue. Does this fall under sariqa or not? We're going to take a short break and we'll be back soon, inshallah. Assalamu alaikum.
Ramadan is a month of forgiveness, a month of repentance, a month of washing away our sins. I wish all the viewers of Peace TV, Ramadan Mubarak.
Explore the wisdom and balance of Islamic law, and the genius of Muslim jurists who distilled the essence of the law into short statements of potent meaning. So join me, Riaz Ansary, for a survey of Islamic legal maxims.
Appreciate the accountability of Islamic laws against all manner of corrupt practices in Islamic Legal Maxims with Riaz Ansary every Sunday at 7 p.m. UK and 8 p.m. Europe on Peace TV.
Assalamu alaikum, welcome back. So we're discussing definitions and their place in the whole process of delivering a hukum, a sharia hukum on anything. So most Muslims are aware that it's not just good or bad. There's a 5-part classification scheme, which is wajib, that which is obligatory. If you do it, you have a promise of reward. If you don't do it, you have a threat of punishment. And the opposite of that is haram. If you do it, you have a threat of punishment. And if you don't do it consciously, that it's because it's haram, then you get a reward. And then you have the mandub, which is that which, if you do it, you have a promise of reward. And if you don't do it, there's no threat of punishment. And the opposite of that is makruh. If you don't do it because it's makruh, then you are promised a reward for that, for your abstention. And if you do it, then there's no penalty. And mubah is neutral. It's permissible, and there's no reward or punishment per se attached to the act. So this is the hukum shar'i. And in order to begin to discuss any topic in fiqh, you have to start with definition. So for instance, in any fiqh book, like as-sariqa, theft, in discussing, before even getting to the hukum for it, the discussion will start with, well, what is sariqa? What is theft? You know, and they'll define it: to take something secretly from a protected place, something belonging to another person, taken secretly from or furtively from a protected place. So based on that definition, there are certain things that cannot be classified as theft. So if somebody comes up to you on the street and puts a gun in your face and says, "Give me your money," that's not sariqa Islamically. That's something else. It's not sariqa. And if you leave something in the middle of the street and you go away and you do something and you come back and it's gone, well, somebody took it, but you didn't leave it in a protected place. So definitions are really important in fiqh issues. And so if there's another word, like in Arabic, there's a word for someone who digs up a grave and takes the funeral shroud off the body. You know, in previous times, people were so poor that they would steal cloth from a grave. So there's a specific word for that, nabash in Arabic. So because there's a specific word for it, then scholars discuss the issue. Does this fall under sariqa or not? So the example of sariqa, theft, you have to fulfill all of the elements of the definition in order to have an act which would be classified as sariqa. And then you could begin to discuss whether the hukm applies on a case-by-case basis. And because of the importance of, and definitions relate to things that involve properties of the acts or the things in question, you have fiqh issues that sometimes a person was asked for a judgment about something and they just went with the label. They made a mistake. So at a certain point in history, coffee became, something that was introduced into Muslim lands. I mean, it actually started, it was cultivated in Yemen. But as it began to be produced for drinking and people began to drink more of it, and scholars were asked to give a ruling about it. So, this is mentioned in the books of the history of fiqh, that there was somebody who delivered a ruling that, the word qahwa, in classical Arabic poetry, it's used for wine. And so, this stuff is called qahwa, and so therefore, qahwa is a type of khamr, and therefore it's prohibited. That kind of a hasty legal judgment without investigating the attributes of coffee is blameworthy on the part of the jurist who did that. Another example of that is a porpoise. There's an animal that lives in the ocean, and the Arabs happen to call it khinzir al-bahr, the sea pig, the pig of the sea. And some scholars said, khinzir, all khinzir is prohibited. The name says khinzir. The khinzir that lives on land, the pig on the land, has no relationship to this porpoise. So that kind of a process is invalid. And you see the Prophet ﷺ giving guidance on this issue in the way he delivered fatwas when he was asked about things. Somebody came from Yemen and he said, we have a drink that we make made out of sorghum, which is it's a kind of grain, sort of like wheat. And we make a drink from it and we call it such and such. Is this halal or haram? So the Prophet ﷺ said, does it intoxicate? He said, yes. He said, then it's haram. Kullu muskirin haram. Everything that intoxicates is prohibited. Similarly, people asked him about exchanging dried dates for fresh dates. And he said, أَيَنْقُصُ الرُّطُبْ إِذَا يَبِسْ? Does the fresh date decrease in volume and weight when it dries out? They said, yes. He said, in that case, you can't exchange dry dates for fresh, because that brings into play the Sharia prohibition of there are certain commodities you can't exchange them except like for like, mithlan bimithl. And so when you're exchanging fresh for dry, it'll end up being, if you're exchanging 10 kilos of this for 10 kilos of that, the 10 kilos of the fresh dates will not stay 10 kilos over a period of time. So this whole process of identifying the effective factors for the ruling is a key issue in fiqh and in ijtihad. And one of the names for this process is called takyif fiqhi. What that means is deciding, what is this thing? What is the essence of this thing? So when insurance was first introduced, it came to Muslim lands from Western lands. So scholars looked at it and said, well, what's going on here? There's a contract, one we're not familiar with. It's an exchange contract. What's being exchanged? Well, there's money. The person who's buying the insurance policy is giving money to the other party, and the other party may be giving money back, and depends on a trigger event, whether it occurs or not. And the amount paid by the subscriber and the amount paid by the insurer will rarely be the same amount. And perhaps the subscriber will pay and the insurer will not pay at all. So this invoked many, many Sharia problems. You have riba, you have gharar, you have all kinds of difficulties with that kind of arrangement when it is an exchange contract. So based on that legal analysis, the overwhelming majority of Muslim jurists have ruled that conventional insurance is haram. And you see also examples of the same process in cases like capital guarantee, capital protection. Well, there's this modern financial product called structured products, where somebody sells two kind of things to investors. There's two separate contracts. One is a risky derivative, and one is something which is relatively safe by conventional terms, like a bond. So the two terms sound similar, but they're not the same. Capital guarantee means that the person who's selling it will guarantee the capital of the investor. Capital protected means that it involves a bond, which as long as the bond issuer is solvent, that's a fairly safe investment. But it's not by any means certain. And because the two terms sound similar, there were all kinds of investors who got into these investments without realizing what was actually being said, and they didn't read the fine print, and then they ended up losing a lot of money. And when the complaints about this misleading use of terminology began to mount, and some of the regulatory authorities in certain countries, like for instance in Singapore, they prohibited these companies that were offering these investment products from using a term like protected capital. Another example in our time, for instance, with regard to Muslim criticism of Darwin's theory of evolution, sometimes the kind of arguments that people present to try to refute the theory indicates that they really haven't studied it at all. I mean, there are major problems with Darwin's theory of evolution, but not every argument that is presented against it is a valid argument. So for instance, some people will say, well, if evolution really is true, then why don't we see horses turning into some other animal before our eye, over the period of our lifetime? The theory doesn't say that, doesn't involve that as a prediction. So try to attack the theory on that basis means you haven't studied it and you don't really understand what they're saying. So for anything that Muslims are confronted with, we need to familiarize ourselves with the ins and outs of what it is that's being discussed and what it is that's being proposed in order to know its weaknesses, its strengths, its flaws, and to know how to accurately refute it if it is indeed flawed. So that is a major issue in fiqh. And that's it for this episode. Assalamu alaikum wa rahmatullahi wa barakatuh.
إلهي أنت ربي ذو الجلال علمت بما نويت بلا جدال